All rise. Be seated. Good afternoon, everyone. Welcome to the October docket of the Kansas Court of Appeals, sitting right here in Topeka. I'm Judge Tom Malone. To my right is Judge Angela Coble, and to my left is Judge Sean Hatfield. We are the panel for today's cases. I'll call the cases in the order of the published docket. We only have a couple this afternoon. When I call your case, come forward, and we'll start off by getting your appearance. And then just a brief orientation. In case you're not aware, we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind during the limited amount of time that you have to make your argument. As presiding judge, I'll be in track of the time. Each side is given 15 minutes for your argument. The appellant's attorney should let us know at the beginning if you wish to reserve any of your time for rebuttal. And after we hear the cases this afternoon, after the arguments, your case will be deemed submitted for decision. And we will then take the case under advisement and get a written opinion out to you and your clients just as soon as we can. So with that, I'll go ahead and call the first case on the docket. And it is from right here in Shawnee County. It's 127-815, the state of Kansas versus Emmanuel Rashad Walker. We have Mr. Meharry for the appellant.
Peter Meharry for the appellant, Emmanuel Walker, Your Honor.
And for the appellee.
State of Kansas through Assistant District Attorney Carolyn Smith.
All right, thank you. Mr. Meharry, do you wish to reserve any of your time for rebuttal?
3 minutes, Your Honor.
3 minutes, that is granted. You may begin.
May it please the court. Peter Meharry for Emmanuel Walker. This case comes before this court after an altercation here in Topeka that ultimately cost a gentleman his life. Out of that altercation, Mr. Walker was convicted of second-degree murder. And we've raised a couple issues on appeal with regard to how the jury was instructed on what we believe was mostly the central issue at trial, and whether or not this was a case of self-defense or maybe imperfect self-defense. The first issue deals with the district court's decision sua sponte to instruct the jury on the doctrine of being an initial aggressor. That was objected to below by defense counsel, arguing that there was no basis for such an instruction. And we believe that the objection below was well taken because there is no basis for an initial aggressor instruction in this case. The facts of the case, looking at them from the state light most favorable to the state, are that this was an ongoing altercation between my client, Emmanuel Walker, and Mr. Sexton. In the midst of that argument, according to the state's witness, my client said, "Hey, back up or I'll shoot." The response from the victim in this case was, "Go ahead and do it." And that individual also then stepped into my client. The district court used that statement as a basis for the instruction. We believe that's the incorrect way to view the situation, because initial aggressor has to be the initial aggressor. And here we have an ongoing argument, and the facts in front of the court were that this was started by Mr. Sexton. He was the one that went to the apartment complex looking for my client. He's the one that started the argument and continued the argument. Even at times where my client backed away, he went and sat on a retaining wall. Mr. Sexton still went up towards him, continuing the argument, continuing the confrontation. And the district court impermissibly basically split the argument up, looked at bits and pieces of it, not who started the argument. And that's why the initial aggressor argument, or excuse me, initial aggressor instruction was without a factual basis here. We believe it essentially poisoned the defense of self-defense. It would have made the jury believe my client did not have that defense, because when you read the initial aggressor instruction, it requires additional hurdles to claim self-defense. You have to either, have no opportunity to retreat, or, try to retreat but are unable to, or you have to withdraw. And certainly the facts here were that that was not the case. That wouldn't apply. This was a situation that occurred outside. So it wasn't like my client was cornered in a basement or anything like that. So the jury would have read that and automatically said, well, self-defense does not apply here. And that's why we believe it's not only improper to give that instruction, but also was very prejudicial to my client because, as I said before, the main issue at trial was self-defense. The second issue that we raise in our brief deals with the failure of the district court to instruct the jury on involuntary manslaughter, specifically involuntary manslaughter, imperfect self-defense. The district court did instruct the jury on several lesser included offenses, including voluntary manslaughter and reckless versions of involuntary and second-degree murder. However, we believe that involuntary manslaughter, imperfect self-defense was warranted in this case. I don't believe the state, and the state can certainly correct me if I'm wrong, is arguing that it wasn't factually and legally appropriate. Their main argument is that it would have made no difference. We believe it was a key instruction in this case because it fills a hole that the other instructions didn't fit with regard to the facts of this case. As I said, the issue was self-defense. Imperfect self-defense under involuntary manslaughter deals with a situation where you're doing a lawful act but using excessive force. And here you could certainly see with the facts given that the jury would have come to the conclusion, look, there was an ongoing altercation. Mr. Sexton was being aggressive, confrontational, threatening to my client. He was entitled to use some level of force to defend himself. However, you could certainly see where the jury would say using a gun was excessive in this situation. There's no indication, no testimony, no evidence that Mr. Sexton had a weapon. There was no indication that Mr. Sexton had been violent as far as physically towards my client before that. you could see where the jury would say, well, that fits the facts of this case. That's why it was important to the jury have that option when they're considering this case. So we believe that when you look at how the jury was instructed in this case, both with regard to the initial aggressor instruction and also the failure to instruct on involuntary manslaughter, that my client did not get a fair shake at trial, and it warrants a new trial. The jury just simply was not properly instructed on how to apply self-defense, how to apply it as to the facts of the case, and also given the proper options as far as lesser included to consider what was appropriate conviction in this case.
Counsel, oh,
I'm sorry.
sorry.
Your client did get the reckless involuntary manslaughter instruction, is that right?
That's correct. Yeah, it was both reckless involuntary and reckless second.
And then on the initial aggressor, did the judge give that instruction? Was that based on Ripple's testimony?
Yes, that's what the judge said when he explained, over objection why I'm giving this was based on the statement Ripple, the witness, testified to as far as what my client said. That was contested at trial, but that was the basis for the district court's instruction.
Right. Sorry.
Well, and my question went to your statement about the initial aggressor. I mean, you're describing the victim then as the initial aggressor because he started the argument. But what's the distinction between he's initial aggressor for starting the argument versus who's the one who provoked force? And I think that maybe is the distinction that I'm struggling with a little bit because wasn't it Mr. Walker who first said, I'll shoot you? So is that provocation of force, is that what we should look at in terms of the initial aggressor instruction?
I don't believe so. I believe it's the person who initiated the altercation. Whether or not then it escalated because of one person or the other. I think you've got to look at the very beginning. What started this altercation? And in this case, the evidence was it was not my client. He was reactive, and his response, his statement that the state claims he made that, hey, back up or I'm going to shoot, that was reactionary to the threat he felt he faced. So when you look at the argument itself, you can't piecemeal it. I mean, you could see a scenario where then, okay, a guy comes into a bar and punches another guy, starts punching him and punching him. And the guy says, hey, get off me or I'm going to shoot. Well, that's not where initial aggressor comes into play. And that's what we have here. Now, we're not dealing with fisticuffs, but it's still an altercation where my client is being threatened. And this bleeds a little bit into the involuntary argument, he has the right to use some level of force here. But when you put in the initial aggressor instruction, that is limiting him. It's limiting the jury's consideration of his defense when he was not the initial aggressor. As I said, we believe that those two issues, and I'll submit the third one. I recognize that there is case law against me on that, and this court is bound by the Supreme Court's opinions on that. But I would submit the third issue. But I believe those first two issues improperly undercut my client's ability to have a fair trial in this case and have his defense properly considered by the jury. Thank you.
Thank you.
May it please the court, Assistant District Attorney Carolyn Smith for the state of Kansas. Defense counsel is correct that this case was an issue for the jury, and the jury was given proper instruction and full opportunity to consider the facts of this case because it is very, very factually specific and determinative. In this altercation, three people were there for it and only two came out of it. We have the eyewitness who gave her version of events, and we have the defendant who gave his version of events. And based on those, the full and complete instruction on self-defense, including the initial aggressor instruction, was proper. The district court deemed it was proper based on defendant's claim of self-defense, as well as the eyewitness testimony that the defendant was the initial aggressor, that both men were having an argument, but they were not physically fighting with each other up until the point when the defendant threatened to shoot. That was based on the eyewitness's testimony and thus made the initial aggressor instruction proper. Now, one of the cases cited in defense's brief is State v. Adam, where there was an error found in giving the instruction, but that instruction was improper because there was a legal mistake in giving it. Additionally, the Supreme Court found that the district court failed to give the instruction that tells the jury the burden does not shift away from the state when a self-defense is asserted. The state still has to prove beyond a reasonable doubt that the defendant did not act in self-defense. And giving that full and complete instruction would have aided the jury in guiding the jury in considering the evidence. The full instruction was given in this case. The instruction as a whole told the jury the defendant is raising self-defense. It is up to the jury to determine whether or not he acted in self-defense. The state has to prove that he did not act in self-defense, and the defendant doesn't have to prove anything. It is permissible to act in self-defense and to use force, and that there is no legal requirement to retreat. And by giving the full entire instruction, properly told the jury how to consider the evidence, how to view and weigh the credibility of the witnesses in this case. And when considering the instructions, they have to be considered as a whole, not in isolation. Additionally, another case from the Kansas Supreme Court said that the initial aggressor instruction is proper when it doesn't identify the defendant as the aggressor. It just says if somebody is an initial aggressor, they can't then claim self-defense. Further, even if giving the instruction was improper, any error was harmless. And I understand that because defense is claiming that this hindered his ability to raise a defense, that this is constitutional harmlessness. And that's viewing the evidence in light of the entire record and determining, as outlined in State v. Brown, that there is no reasonable possibility that the error contributed to the jury verdict. And in this case, the evidence was clear that the jury was instructed on the proper burden of proof, that it remained with the state. The jury was again instructed within the self-defense instruction that the burden remained with the state. Defense counsel in closing arguments said that the burden is on the state. It never shifts. And the jury was to be hold the state to that burden. And the state held its burden in this case because the evidence came down to what the eyewitness said and what the defendant said. And both stories, although line up in some respects, are conflicting in who was the aggressor in this case. And looking at defendant's testimony alone paints one picture, and looking at the eyewitness's testimony alone paints one picture. But that was what instructing the jury was for. That was the purpose of the jury in this case, was to view the evidence, give weight to the witness's evidence, give weight to the testimony, and give credibility determinations. Moving on to the lesser included instructions, defense counsel below asked for all of the lesser includeds, and the court gave all the lesser includeds. In fact, 4 additional lesser includeds to the initial charge of first degree was given, including imperfect self-defense, voluntary manslaughter, or a honest belief that circumstances existed that justified deadly force for voluntary manslaughter. Each of these were given to the jury properly, and the jury was instructed that if you don't find this, then you must consider this. And if you don't find this, then you must consider this. The elements instructions are not viewed in a vacuum or in combination with each other. The jurors follow the instructions down the line to make their determinations. And in this case, they never made it past second degree intentional. And the jury is presumed to follow the instructions as they are given. And adding an additional lesser included down at the bottom of this list does not mean that they would have reached that after looking at the evidence, believing that they've made all of their own determinations on credibility in reaching their verdict and deciding that second degree intentional was the conviction that they wanted to go with and the conviction that they did go with. And I understand that the skip rule, as I cited in my brief, is not to be mechanically applied, but in this case, with so many other lesser includeds given and still being convicted of the highest, it just doesn't seem that giving an additional lesser would have altered the verdict under the circumstances of this case and having not been requested in the first place. There's just
Didn't the Supreme Court criticize the skip rule somewhere along the line? I seem to vaguely recall something like that.
I do not know, Your Honor. I don't have a clear memory. It might be, and I think that comes to with it not being mechanically applied. It's not an automatic. Well, this is a loss. Obviously, we conceded that had it been given, had a conviction been held under that crime, it probably would have been supported. If you take pieces of the eyewitness testimony, if you take pieces of the defendant's testimony, many of these crimes could have been upheld based on the evidence just because it's so fact-based on human testimony. You know, there's not.
You're conceding that the instruction would have been factually and legally appropriate.
That is correct, Your Honor. But I do not
We're
believe.
just saying wasn't clear error, not to fail to give them that.
That is correct, Your Honor. And I think that comes just down to the nature of this case where nothing's on video. Everything was determined. Any of the technical evidence was picked up after the fact based on the autopsy, photos of the scene. But everything that happened during the crime is all based on a witness's testimony and their recollections. And in that case, it, as I stated at the beginning, always comes down to what credibility and what weight the jury gives each piece of evidence that they are provided. And giving the jury an additional instruction would not have changed the verdict in this case because the jury made their credibility findings. Based on their verdict, the jury found the eyewitness credible. They found her story, her version of events to be the more credible version. And I know it's not this court's job to reweigh the evidence, but looking at the verdict, it indicates and shows that any additional instructions would not have changed the outcome. I believe that I will stand on the arguments made for the third issue, the sentencing issue, as defense counsel said, that is a well argued and decided issue based on prior case law. I think if there are no further questions, I will concede the rest of my time and I will stand on my brief.
Thank you, counsel. Let me lead off with a question on the initial aggressor instruction. It just seems to me that it's sort of a benign yet correct statement of the law. I mean, all it says is a person who initially provokes the use of force against himself is not permitted to use force to defend himself. It's not saying that your client was the initial aggressor, and I presume defense counsel argued in closing argument that he wasn't. So wasn't that just for the jury to sort out a factual issue?
Well, I think a couple things. Number one, it certainly follows statutory language. It follows BIC language, and we're not saying it was legally incorrect. The problem is the district court said, I think it applies because of the state testimony of the state's witness. And I think it's a fair assumption that when a jury got this instruction, they would go down the same route and then apply this to my client. Our argument is a little weird that we're saying that it wasn't factually appropriate, kind of because the district court looked at the facts wrong. It did not look at what started the argument, what started the altercation. It looked in the middle of the argument to see who made a statement threatening to shoot.
But is that the requirement? Do we have authority to say that is the point at which the court was required to start looking?
I think when the doctrine is called the initial aggressor doctrine, you have to start at the beginning. You don't look at things mid-fight. And that's what the district court here is. I don't know of a case that says that point blank. I didn't find one, but I think when you talk about, okay, we apply, plain language, we get words that are ordinary, common understanding. When you're talking about being an initial aggressor, you have to be the one that starts the fight. And that's not what occurred here. And that's why that instruction was inappropriate. Like I said, I think it's fair to assume or presume that the jury went down the same path the district court did when it looked at this instruction.
But isn't that like saying, well, we instructed the jury on first-degree murder, so they're going to convict him of first-degree murder? I mean, is that not the same sort of rationale?
No, I don't think it is, because we assume juries follow the instruction, and they would have gotten this instruction. And I think the assumption is the jury would conclude this applies. We aren't getting this for no apparent reason. This applies to this case, and that's why it would have applied it to my client when it should not have been. And that's the danger here, is they apply it, and this court, actually it wasn't this court, it was court above, has talked about how initial aggressor, when you have that doctrine, that raises the threshold of proof for self-defense. It makes self-defense harder. And that's what happened here. And it wasn't a situation which warranted it. So we believe it was improper, and it did affect the jury, and it did affect the ultimate verdict. Thank you.
Thank you, counsel. Thank you very much for your briefs and your arguments today. We'll take the case under advisement and get an opinion out to you just as soon as we can. Thank you. The last case on the docket is from Cloud County. It's number 127675 in the matter of the estate of Gloria Ann Hamill. Hamill, okay. And who do we have here for the appellant?
It please the court, Your Honor, Richard Dietz, attorney from Osborne, Kansas. I am legal counsel for petitioner Robert Hamill, who will be referred to as Bob in my oral argument today. The appellee, respondent Janice Street, will be referred to as Janice in my oral argument. Bob's and Janice's parents, the testators of a joint and contractual will, the admissibility of which is at issue in this case, will be referred to as Wilfred and Gloria in my oral argument. Your Honor, I do request 3 minutes for rebuttal.
That's granted. And who do we have for the appellee? All right. Mr. Dietz, you can begin your argument.
Thank you.
And bear in mind, we we're familiar with the facts, so you can kind of just jump right into it.
Your Honor, the premise of Bob's case is that an innocent beneficiary of a will could be entitled to the 90-day extension provided for in KSA 59618 to submit the will for probate when the innocent beneficiary has been unable to have knowledge of the will or access to the will for a period of time less than 90 days within the 6-month limitation in KSA 59617.
So what triggers that statute in the first place?
The triggering of the statute would be the submission or the disclosure of the will
Someone
to the
has,
beneficiary.
someone has to knowingly and willingly fail to disclose the will, right?
No, Your Honor. The will, everyone should have a right, every innocent beneficiary, whether the will is knowingly withheld or not, should have a right, we submit, to the 90 days under 618, 59618. Because, Your Honor, it does not really make meaningful sense if a will would be knowingly withheld from an innocent beneficiary within the 6-month period of time of 617. If that were to occur, then a knowingly withheld will, the innocent beneficiary could have less than a few minutes. If that occurred,
I get that.
yes, if that occurred before the expiration of the 6 months. If it occurs after the expiration, if it's knowingly withheld, then you have 90 days.
And you're focused on how long it has to be knowingly withheld. But my question is, and I'm looking at the statute, to trigger the statute at all, someone has to knowingly withhold the will for a certain amount of time. Would you at least agree with that?
Your Honor, I don't know that it has to be knowingly withheld. I realize that at trial that Bob contended that Attorney Condrey knowingly withheld, as well as even a contention that Janice withheld. The trial court found that it was not a knowing withholding, it was a mistaken withholding. That Mr. Condrey wrongly thought the will was not admissible to probate. He did not disclose the existence of the will to Bob in this case until there were questions of Janice. Janice contacted Mr. Condrey. Condrey then on September 16th emailed a copy of the will to Bob.
Yeah,
That left him 35 days, okay, within the 6-month limitation of 617. If that would have happened after, about 46 more days, then, then Bob would have had 90 days. We submit that certainly it's obvious that the intent of the legislature has determined that 90 days is a reasonable period of time for a will to be submitted for probate. We contend that if you read a proper reading of 617 and 618 is that why should less than 90 days, as in this case, be allowed to submit the will to probate? Why would 90 days, the legislature has determined 90 days is a reasonable period of time. We contend that should apply even in this case. Maybe it was a mistake on Mr. Condrey's part, but Mr. Condrey did not disclose that to Bob until about a month was left of the 6-month period of time, or the limitation under 59617.
He didn't know Gloria was deceased. That's what he testified.
Even then, really, the goal should be the legislative intent is really to protect an innocent beneficiary. Bob is an innocent beneficiary. Whether Mr. Condrey, which he testified, well, he didn't know about Gloria's death until probably about the time that Janice had appeared, got a hold of him shortly before September 16th, okay? Where a point in time where the 6-month limitation had almost run. And certainly, why should Bob in a situation like that have less time than an innocent beneficiary when the will is withheld after 6 months is run?
I just want to make sure I understand the fact. Your client, Bob, he doesn't really have a financial stake in this, does he? He's going to get the same percentage.
If you really look at the change that Gloria made, he even received less because of her greater distributions, the amount of money given to the Catholic Church.
Charities.
So he did, you know, whether you want to measure it by a great amount or not, the ones who really suffered in this case were Gloria's grandchildren of the deceased sons. So we submit, Your Honor, that really a proper reading of 617 and 618 is that really every innocent beneficiary should certainly have at least 90 days once that will, he has knowledge of it and access to it, to submit the will to probate. Why should he have less time? Wasn't his fault that Mr. Condrey, whether he knew about the will before then or not, it appears that he did. If you look at the evidence that was brought out in court, he knew about the will at the time of Gloria's death. Now, he may not have heard about her death until later, but he waited there was 5 months. If he didn't know about Gloria's death, you can argue that, he didn't wait. But the key is we have an innocent beneficiary, which in my opinion could happen in many cases, that was given less time to submit the will for probate than he would have if it had been a knowingly withheld will under 618. But 618 and 617 should be read together. It's obvious that the Kansas legislature believes that every innocent beneficiary should have 90 days to submit a will to probate.
But we don't even get to intent, right, counsel, unless the language of the statute is somehow ambiguous. We're not looking at intent, we're looking at the language, and 617 clearly says knowingly withholds in the first sentence, and then that second sentence, such will may be admitted to any innocent beneficiary. I mean, it looks like to me the statute clearly says it has to be knowingly withheld. So how do we get past that statutory language?
Your Honor, I believe when you read those two statutes together, it's obvious that an innocent beneficiary should have 90 days to submit a will to probate. You know, the question is, why should Bob have had less time, less than 90 days to submit a will to probate? It's pretty obvious what the legislature intends. It intends for every innocent beneficiary to have 90 days from his knowledge of and access to the will to submit it to probate.
But it doesn't say that exactly. You want us to read into the legislative intent. It doesn't, those words aren't there. You want us to kind of imply what the legislator intended to do, right?
Yes, Your Honor, because it is what you end up with is a meaningless result. Again, why should someone in Bob's position have less time to submit that to probate than the 90 days? As I say, you can read those two statutes together, and certainly the legislature believes that every innocent beneficiary should have 90 days to submit that will to probate.
But he did have a significant amount of time. He had 35 days? So it wasn't like you said earlier, it was submitted with just a few minutes left to go on the clock. He had 35 days.
Your Honor, again, that's certainly a lot less than 90 days. That's about a third of the time. I mean, where are you going to draw the line there? It would seem to me that it's pretty obvious that 90 days is the line. That's what our legislature thinks. Thank you.
Thank you. Mr. Thompson, whenever you're ready.
Good afternoon, may it please the court. How long must a will be knowingly withheld? 6 months. That's what the statute says. On
But
behalf,
I'm sorry.
sorry. On behalf of Ms. Strait, we're asking the court to follow the directions that came down from the Supreme Court case of Strader in the state of Strader, where the court already considered pretty much the exact same argument. They disapproved the Court of Appeals case Tracy that made the same arguments that the appellate is making here. Tracy argued that being an innocent beneficiary is enough. And Strader said, no, it's not. You can be an innocent beneficiary, but you must have the knowing withholding to go along with it. And a lost will, a misplaced will, that's not knowing withholding.
Let me ask a completely unrelated question, and it probably doesn't impact the resolution of this case, but was the pour over will ever admitted into probate?
No, it was not. If it makes any difference, the pour over will revoked the original 1985 will, but as the court rulings came along.
Well, you would think if that was her last valid will, it would have got admitted into probate.
Well, the district court ruled that the original 1985 will was valid and it was a contractual will.
Contractual, I understand that. but-
Lori Hamill's attorney didn't agree with that, and of course I'm on that same side, but we didn't win on any of those arguments in the district court. This case turned on that knowing withholding. The district court was very explicit. There was no knowing withholding. That being the case, I believe that's a negative finding, and for a court to evaluate that or overturn that, there must be passion or prejudice or some type of ignoring of substantial evidence. Those arguments aren't made by the appellate here. I understand that they agree that they don't want to go down that route and they have the right to argue that the attorney did knowingly withhold that, but the court's already found that no, that didn't happen. It's already been mentioned that with 35 days left, the will, the trust, and everything was immediately turned over to Mr. Hamill. 35 days is enough time to get it admitted or file your petition if he would have addressed that matter. Now, Mr. Dietz makes a hypothetical question that has logic. That's not what happened here. Although the courts want to admit all the legally proper wills, there's also a basis for achieving finality. In this case, like many others, seems to go on forever. When can a trustee or when can an executor finally get to the point where they can distribute the assets? I'm wondering why we can find anybody willing to take those jobs anymore, because these cases never get over with and challenge after challenge after challenge comes along. The finality that's inherent in 59-617 at least gives them some chance of getting things over with and distributing those benefits. But if you don't have a distinct, definite rule, and there is no well, what if he had 90 days and what about this and what about that? Again, nobody's going to take that job because it's too confusing. Now, that's one policy reason for not giving this extra time from 518. But the court considered what it would be like if every attorney that drafted a will had to keep track of all their old clients to know whether they passed away or not. In our office, we have 50 years of old, well, maybe more than that, of old wills, and we don't know where those people have all passed away. Many of them have moved away while they're still alive. How could we know? How could any lawyer know whether his past client of 30 or 40 years ago is still alive? And if they are still alive or not, did they revoke that original will? That's very common. It happens all the time. They could tear it up and it's revoked. How do you deal with that situation? The court in Strader didn't make a policy decision. They went back to the plain language of the statute. And their points of emphasis were that when you have plain language in statute, you don't have to go to the intent of the legislature. You don't have to go beyond what that plain language says if it's clear. And it is clear. You have to have a knowing withholding. I don't know how you can get around with that. And in the same sentence, it has to be for 6 months. Looking at all these.
So what about the hypothetical scenario that someone found out about a will 12 hours before the 6-month deadline?
Well, that'd be a tough situation to argue against. And I don't think the unique circumstances is doctrine is proper to be on the court's consideration today because it wasn't argued at the district court level. But if there was ever a unique circumstance, that would be it. Finding out about a will that just a few hours before it could be impossible to get it done within the 6-month time limit. But looking at those unique circumstances cases, nobody ever benefits from the exception. No proponent of a will benefits from an exception, no matter what you argue, whether it's 618 or unique circumstances, unless they were completely prohibited from filing the will because it was longer than 6 months. Sometimes it was lots longer than 6 months. When the court loses it, by the way, that's one of the requirements of unique circumstances. When the court loses the will, it's their fault. When some lawyer's office misplaces it and has it locked in some file someplace, again, you can't be much more of an innocent beneficiary than that. But we're far away from that situation here. Mr. Hamill asked for the will, he asked for trust information, got it immediately. Now, I'm not that fast myself as answering people's emails within 24 hours, but it happened here. And Mr. Hamill could have easily got the petition filed within 90 days. They didn't do it. There has to be some type of finality or some type of rule to solve every situation or attempt to solve every situation. But that's a matter for the legislature to decide. Again, we're asking the court to follow the Strader case, to go by the plain language of the statute. Any additional questions?
Apparently not, thank you. Yes, sir. Still have 3 minutes, I believe. Yeah.
Your Honor, counsel for Janice cites the Strader case. The Strader case is different than this case. In fact, that was amazing. The will was found in a law office. I think it was maybe 1-2 years. It was quite a significant amount of time. So it was a will that apparently had been misplaced or lost and showed up quite some time after the 6 months under 617. So we do not believe that Strader really is a case that can be looked at as a precedent for determination in this matter. And we again submit that we cannot see an argument as to why Bob should have had less time than if there would have been a knowingly withheld will after the 6-month period. You can argue 35 days out of 6 months. Well, that's enough time. That's not necessarily that much time for the innocent beneficiary to get an appointment with an attorney and get in and see the attorney to review the documents. So we submit that he should have had 90 days. When you read 617 and 618 together, he should have had at least the 90 days to submit that will to probate. Thank you.
Thank you, counsel, very much. We appreciate your briefs and your arguments. As I said in other cases, we'll take it under advisement. And I know you're anxious to get an opinion, and we'll get something out to you just as soon as we can. With that, court is adjourned for the day.